Good evening, everyone. This is Abhivardhan from Internationalism, and here we have the ninth episode, season 2 of Global Hint. So, in the last episode, which we had yesterday at 7 p.m. IST, we had discussed about the Abraham Accords and the very scope of the same in the Indo-Pacific region, and we had connected various states dots accordingly. So, as I had promised, here we have the second dialogue of Indo-Pacific Mobility Forum 2021, which is of course the ninth episode of the second season of this particular show. And I'd like to say that the biggest discussion for IPMF 2021, which is the 15th episode of Indistinct, is coming at 7:30, which is on Indic languages and information age. So do wait for that at 7:30. But till then, this is a quick dialogue which we are going to have on international refugee law, and we have a very interesting set of people who will be in this dialogue discussing about India's national security considerations with respect to refugee policy and its implementation. You know very well who is Karthikeya. He's on Twitter. He is an academic. He actually is associated. He has worked on UK immigration system. I'll introduce Ashish Yadavji. So Ashish is a lecturer at JGLS, and he has worked on issues related to international refugee law in an academic sense. So, to begin with, let us make the we have the canvas. Let's just make the sketch. Let us draw around the pointers and understand what are we going to discuss. Now, one inspiration that we got behind this discussion was a very interesting article by Karthikeya, which is published on Medium, medium.com/@Karthikeya Mishra. You can read that. The article specifically focuses on India's position on refugee law. And of course, there are contemporary legal issues which always emerge, which always pop out because of serious issues in India's refugee policy altogether. So, to begin with, I'd like Karthikeya to make some context, and of course, after that, I think Ashish can bridge it up further because that's I'm considering that this discussion is also inspired by his article. So, when we talk about India's refugee policy in a contemporary sense, so how do you think it has emerged in a simple way for a contemporary understanding for anyone who doesn't know at the first place? So we're just making a background so that we can proceed in a much comfortable sense.
Okay. First of all, thank you, Abhivardhan, for having me. And first, I would like to say that what was the triggering point for me to write that article? So first, I never actually we in India we don't have a proper asylum system, so we seldom study, how refugee policy works unless you study international law and human rights, and then you get to know what the policy is. And India is not the part of the Refugee Convention 1951, so of course there are no domestic, laws or policies advancing those obligations. So there's a clear lacuna, and considering because I have some experience in working in the asylum system in the UK and general interest and my academic relationship with international law, I came to know about how these things work, and I thought that India desperately needs it because it's just not good enough in this country, and we seldom discuss about it in public discourse. It's never a part of policy making. And I think it was only Shashi Tharoor in 2015 when he introduced a draft legislation, a private member bill in the parliament, which didn't pass. And I don't think that was a perfect law for this. But all these factors together, triggered me to write something because climate crisis is very real, and Bangladesh and eastern part of India are going to be on the forefront of this climate issue. And of course, climate change, climate catastrophe would trigger a mass migration of people, displaced people due to climate. And this is why I thought that it is very important to write something, at least to just contribute a bit to the discourse, because anyway, I'm not in the policy making. I'm not someone who practices this in India. So of course, it was just a small attempt. But that is what I want to say in the first place. Now, second, coming to, as I said, that India doesn't have an asylum policy. I think that is something which we could discuss in the later issue of this episode, in the second part. In the first, I would just want to say that defining climate. So this topic which I wrote was not only about the climate refugees. Of course, I wrote that this is something which is going to happen. but also in general we needed a proper asylum system in India, because there is a clear law and policy paralysis where climate change, where refugee movement is concerned. So I would like to just stop here first, and then we'll unfold the other parts in the later section.
That's amazing. So, to begin with the discussion, and my first question, therefore, is to Ashish about it. Uh, why is it that India, from a perspective of international law, has not ratified the 1951 Refugee Convention? You can, of course, give a brief about some aspects of the principles of the Refugee Convention, which starts from the way non-refoulement and all of those work out. And is it there any trace? Because sometimes it happens that India does not ratify certain conventions, but still it adheres certain conventions in principle or in actions or in conduct. Let's say there are some funny cases, but I'm not going to talk about them. So the question is to you: what do you think about it?
Well, thank you, Vivardhan, and thank you for inviting me to this very refreshing session on a very important and pressing issue. I'm just gonna, start with trying to answer your question, and then I think there are so many different and interesting aspects here that we could discuss, as Karthik has also hinted. Just so that I also give a sort of introduction to my foray into this, I studied refugee law well, a bit during my LLB at Delhi University, and then during my master's as well. But since I graduated, I've been working on citizenship, and now because of certain discussions that I've had with my good friend Karthike, I'm trying to get back into refugee law, and it's very nice, and I'm very grateful to you for this platform where I can come and discuss about such interesting issues. So, very good question. Actually, this is, I think, this question would be in the mind of every individual, every law student who tries to pick up the Refugee Convention by themselves. I mean, in Indian universities, we don't have as many refugee law courses, and one might wonder, what is the importance of this convention that was signed 70 years ago? In this June, there was a very significant international conference at the Refugee Law Institute at SOAS, UK. About whether the convention is aging gracefully or whether it should be, swept aside, whether it has been swept aside. It's been 70 years now. The convention has been passed. It has been in operation. India has not been a signatory. And some of the answers to, your questions lie in some work that Pia Oberoi has done. And let me tell you the name of the piece that I'm going to draw my understanding from. Pia Oberoi writes in the York University Journal, and she said the piece is called South Asia and the Creation of the International Refugee Regime, where she says that India and Pakistan in particular were very enthusiastic in the early drafting stages, in the Chava Perpetua stages of the Refugee Convention. They really wanted this convention to shape up, and because their concern was that there were so many partition refugees who could have benefited from this. But as we know, I mean, again, that, read Article 1 of the Refugee Convention, and you see that temporal limit of 1945. You notice that, the convention, 51 convention, only applies to people who had to migrate until 1945. In other words, it only caters to the people who were displaced due to the Second World War. And then what it does is subsequently, partition refugees, Palestinian refugees who were displaced because of the Korean War. This is again happening at the moment when the convention is being drafted and being signed in 51. These refugee groups have been ignored. They were not given protection. So India and Pakistan then feel quite collectively in their, Pia Oberoi discusses many of these conversations that Indian Pakistani delegates had with the US delegates and the UK delegates, which reveals that our two nations, the India and Pakistan, the nations were very uncomfortable with the fact that they were being asked to sign on to a regime which would make them bear the financial burden of refugee settlement, refugee protection in Europe. And on the other hand, people who've been displaced in this region will not get the same benefit, will not be allowed that same sense of protection and international law. So that's why India did not sign eventually. Initially, my bad. And then subsequently, what obviously happens is, and you raised an important point that, sometimes it happens, we see that India has not signed a convention, but yet some laws and some obligations might follow despite the non-ratification status of that international treaty or convention. The same, one could say, has been the case with the Refugee Convention. So we clearly know, I mean, there's no dispute about the fact that the definition of the refugee in the Refugee Convention is now customary international law. All subsequent international treaties and conventions, be it regional conventions or be it, these subsequent UN resolutions which have reiterated the convention, have also said have also repeated the same fact that, okay, the definition of refugee is in fact that one which is contained in the Article 1 of the 51 Convention. Also, I mean, you obviously hinted to non-reforma, again, one of those favorite things of refugee lawyers, and people just sort of, so people make this very convenient jump between Article 1 and Article 33. And what it does, and this has been sort of emerging in scholarship lately, that what it does is it ignores those articles in the middle, which are very important and which we'll speak about, hopefully. Karthik and I were discussing about it yesterday. So non-reform obviously is this right that tells that people who are facing a threat of persecution, who are well-founded fear of persecution in their country of origin, shall not be sent back there, shall not be deported there, and then to use a more everyday colloquial kind of term. So the Refugee Convention gives us these rights, as well as several refugee-specific rights, such as, what shall their status be, the fact that they're entitled to freedom of movement in the host country, the fact that they have some social security, the fact that, most importantly, which we should come to, that there is no penalization for illegal entry, because the convention recognizes that refugees will obviously enter in situations where they may not have documentation. That's what the convention does. Now, anyway, sort of dialing back to what you asked me initially, the international community realizes this, and in 1967 they sign a protocol which does away with the geographic limits, which were Europe, temporal limits, which were 1945. It casts them away, and then Refugee Convention post 67 applies to all across the world and does not have a temporal limit to it. Now, what does India do, and what has India done meanwhile? Quite on the contrary, I mean, despite India's reluctance to the 51 Convention, India has been a very generous host nation. In June 2021, the UNHCR fact sheet for India states that India is hosting upwards of 2 lakh refugees. 95,000 of them are Sri Lankans, 73,000 Tibetans, 22,000 from Myanmar, 15,000 from Afghanistan, and some other mixed groups. Quite a curious thing is that because India is not a signatory, because India has not ratified the convention, the government, the executive, takes some level of control in what groups it allows UNHCR India to process. So Sri Lankans and Tibetans fall under the purview of the Ministry of Home Affairs, and the MHA report every year talks about their different aspects of social life, of their political status, of their residence in the country. So India has also obviously been very receptive to the UNHCR presence over many decades. So, and India has also been a member of the executive committee on the Refugee Convention. So this has been India's involvement with the convention, with the convention rights, you could say, with the convention grounds in many ways. So it's indeed been, I would say, quite engaging without being a party to the convention.
Great. So as we proceed, Karthikeya, would you like to add some follow-up or some pointers to what Ashish stated?
So so just a minute. I don't think there's much to disagree what Ashish said. I think that I don't disagree with any part. I would just like to add some conceptual difference that India had with this convention was that, first of all, as Ashish pointed out very rightly, that this was a very Eurocentric or European idea, and also this was the time when India was hosting more than approximately 15 million refugees from Pakistan, East and West Pakistan, and there was no the benefit of this convention was not granted to India. So that was also a problem. The second conceptual difference was that refugee was seen as an individual. The entire process was individualistic rather than considering them as a constituent group. And it did not address the mixed flows and mass influxes which India was facing. And I think this was more based on a worldview of post-World War era, where they called as the worldview of Weltanschauung, the German word for worldview. And India had a very different historical realities to that. And the third most significant, I would say, was the burden sharing aspect, which Ashish rightly pointed out, because in 1971, leave that, in 1971, when millions of refugees from Bangladesh, East Pakistan or modern day Bangladesh, came to India, there was there was aid, some aid, but that was very inadequate. And at the end of the day, it was the Indian taxpayers who funded for the resettlement or for the management of the refugee. So I think burden sharing was one of the most important aspects which the global south had to suffer just to stop the refugees from moving up north. I think that is a very important thing, part of India's not accepting this convention. So that is just what I wanted to add in this.
Great. So as we proceed with this, I have another question. Since we have to, and a good background has been made. My question to the panelists is related to the status of climate refugees. Now, of course, in the 1951 Convention and the 67 Protocol, it's pretty obvious that climate refugees is something which, as a legal idea, is not included. But for the sake of the viewers, uh, there are certain juridical understandings of it when it comes to what constitutes a climate refugee. I'm not getting into it, but climate refugee specifically is a refugee from a from a particular place, which is subject to climate impact, or let's say climate change, and because of which the place becomes unsustainable for the person, which due to which the person has to leave. Of course, the principles of you know non-refoulement and other things can be applied accordingly. I'm not giving us a very rigid definition, but I'm giving a basic understanding. So, climate refugees are a reality in South Asia. When it comes to the Indo-Pacific region, in the Indo-Pacific, we see that many refugees, I think from Bangladesh, if I'm not wrong, but from maybe Myanmar or other countries, they actually have gone to various countries for gaining asylum, such as I remember Malaysia, for example, in ASEAN region, or India, of course, and even some other countries in the West, especially the Great Britain and the European Union countries. So, to the panelists, the question is quite specific. How should India, as a very important, I would say, territorial country, because this is a territorial issue at the end of the day, and plus the other things which are connected to it, should see the influx and the policy paralysis with respect to climate refugees, not just about recognition but also about taking them up and dealing with their issues at the end of the day, because of course there are structural issues when it comes to adapting a refugee policy, but since we are also discussing climate refugees as a national security imperative, I think we can get much there, and then we can make a clearer aspect. So Ashish, you can begin, and Karthik can continue accordingly.
Yeah, why don't I lay down some other conceptual issue again, and then Karthik can come in. Maybe if afterwards,
Sure.
if I could add something, right? So you raise a very
Definitely.
important point, and just when you were beginning, I went back to the title of this talk, and you very creatively put it, and that is indeed the correct legal understanding. You say climate and other refugees, right? So that's the correct legal. As you said, climate refugees are not covered in the 51 Convention. Now, the issue here is that, because it is understood climate refugees or any person who, let's say, goes to a certain country, crosses a border, and then claims that they've migrated because of climate, it's very difficult to pinpoint climate as the catalyst, as the causal factor, right? Because climate doesn't, it's invisible in many ways, or it's very slow moving, right? It doesn't fit into the understanding of other grounds in the convention, race, nationality, particular social group, or similar points of political opinion, because they are more about political violence. The convention is more centered on persecution at the hands of the state. Now, subsequently, because of the rise of terrorism, because of other particular groups, non-state groups arresting control of states in various territories, that definition has been expanded, and these groups are people who face violence at the hands of these groups are considered refugees. But for climate, it would be very difficult to do. Firstly, it's no one really knows. No, I mean there have been estimates, but there's so much disagreement on the fact that how many refugees how many people will become climate refugees in the coming years, in the coming decades. There have been contradicting estimates as to whether how many countries, these micronations near Australia will either lose land, some country might even gain land. They say that Kiribati will gain some land. That's the new estimate. So we don't know that. But what is certain is that due to slow onset disasters such as desertification, salination, rising sea levels, people will move. And people will move not only as refugees, but also internally. People may also become stateless. Entire countries may drown. Now, what we must keep in mind is UNHCR's role here is obviously implementing the 51 convention, but there have been developments post the 51 convention as well. There are regional frameworks, in particular the 1969 OAU convention and the 1984 Cartagena declaration. Both these instruments recognize the definition. They expand the definition to persons fleeing events seriously disturbing public order. Now, this definition, scholars argue, would probably cover people displaced due to climate change, or people displaced due to climate disasters. Now, despite these understandings, despite this regional jurisprudence, UNHCR, as latest as last year, has reiterated that climate refugee is a term not endorsed by UNHCR. It is more accurate to refer to these people as, quote, persons displaced in the context of disasters and climate change, quote, closed. This is what the UNHCR's understanding is. This is what the 51 Convention says. Now, this doesn't obviously negate the fact that there have been regional practices, there have been national practices as well. There is a very famously quoted case involving New Zealand and a climate refugee, if we can call them that, about giving protection to them. It's an HRC decision called Tiotea versus New Zealand. I'm not pronouncing the name right. It's an indigenous name. So that's been the framework. And most importantly, and this is again something I think we should come back to, there is another concept in international refugee law called complementary protection. There's a 2007 book by Jane McAdam by the same name. And what complementary protection is it says that in territories or in states which have not ratified the 51 Convention, there are still rights which apply to people seeking asylum. These rights, for our sake of understanding, we just call them human rights, right? So then the ICCPR, CRC, CEDAW, Convention Against Torture, these conventions and their subsequent rights, which have also acquired the status of customary international law or use coherence norms, shall make up complementary protection for refugees. So in a country like India, if someone is not able to access refugee rights, they can claim certain human rights. So that's the overall framework. Now, I think Karthikeya can come in, and then maybe I could come back in later on.
So, as Ashish has rightly put, that climate is a catalyst, and for the general viewers, I think the best example would be of a farmer. If there is a drought in that land, the farmer is not moving because of the drought, but because of loss of income. So, can we say that he's a climate refugee? That's something which is very difficult to. So, just like terrorism is hard to define, and similarly climate refugee has been a definition which nobody has come up yet, and there is no official definition yet, and it is so. And I think the most important aspect of climate refugees would be to assess where there is a clear nexus between the movement and the catastrophe. If it was a man-made catastrophe, despite climatic in nature, can we say that it qualifies as a climate refugee? And the migration must be permanent, that they can't go back and settle there. So the movement shouldn't be temporary. It would be permanent and forced. And I think along these points, we can come up with a definition or assessment points where the government can decide on the basis of these points that that okay, certain people are escaping, this issue, and then we can provide certain protection for them. And as Ashish rightly pointed out, India has some international human rights obligations, and India can balance those. That is what the point of my article was, that if there is a provision, there are laws there, the Indian government can formulate this policy properly and can also take care of its national security and other considerations, because every country considers national security when while dealing with, refugee movement and migration. So that's not something which is, which will open up some nasty Pandora's box. It's not like that. It's just like we don't have something. So that is why everything is up to, arbitrariness. That is the problem. And this is why I say that climate refugee is just an aspect. We need to first have a proper asylum law system, asylum courts, people practitioners, legal practitioners who are working in it. And this climate catastrophe will not happen now. It will happen 10 or 15 years later, or maybe, I don't know. Climate change is unpredictable. We don't know, but at least 10 to 15 years. And we have to consider that Bangladesh, if we are talking about Bangladesh, southern Bangladesh and West Bengal, the southern part of West Bengal, are on the same region. So if something happens, it will happen in both areas. So we will have to face internally displaced people from India within Bangladesh, spreading across Bihar and other parts of India, and then people escaping Bangladesh and coming to northern part of Bangladesh, and might trigger northern Bangladeshis to move outside of Bangladesh because of loss of many things. So all these things we need to consider, and we have to have something, at place. So if this happens, we have something to, to regulate this or manage this.
Indeed. So my next question is about the very issues when it comes to uh, asylum laws. Now, we see one thing, and this is an open question to all the panelists as they wish to proceed. I wish speakers, not panelists, because this is a dialogue, and I'm more of a moderator here. So, considering this, we see that the northeast region, and even as you stated, West Bengal, has its own sensitivities when it comes to internal displacement, or basically the issue of becoming a refugee from a foreign country. And this is something which itself is another kind of a problem. So let us critically analyze the kind of national security constraints which come in, which actually lead to India not being adopting an asylum approach. And on that, one point to add from my side, I think a larger reason why India is not able to do is not the general rhetoric which is made or everywhere mainstream, but I think it's a legalese problem, which has a longer relationship with their whole administrative competency and their relationship with the people. Because again, we are not a big state yet. We claim to be one. Big state means you have enough machinery, you still have vacancy and all of those issues. And then for a state which is pre-industrial, that is a big problem. We are still like we are a mixture of problems in that sense, because if you are pre-industrial, you don't have an industrial community which is robust enough. Therefore, you can't ensure how much structuralized reforms you can go undergo. That's why in India, and it's more because of in South Asia, I think more in the Indo-Pacific region, it's a problem because many countries have been facing this. I mean, I'll not mention Pakistan or Afghanistan for that yet, ever, but at least I can say safely for countries like Indonesia or South Korea and others. But South Korea again is a different case. South Korea industrialized in its own way and also neoliberalized in its own way. So India is a very unique case, a pre-industrial society, not a big state yet, trying to become a big state, very important. Not being that is a big issue. There are infrastructure projects in Assam and other states, and yet we see that problems happen between Assam and Mizoram. I'm not mentioning the specific issues, but I'm trying to make an outlier here so that on outline, not outlier, so that the panel, the speakers can take it accordingly. So, how a problem is to be seen when it's more of an administrative aspect when it comes to relationship, and we also see the way administrative authorities deal with it. And I can start even talking about the the way the whole National Register of Indian Citizens things was held in Assam, and what issues were there. But again, should not direct on that so much, because the discussion is itself on asylum law and asylum policy. But of course, that can be one of the examples to start with. So I think I'll give it to the speakers. Whosoever wishes to begin first, please go ahead. Feel free to.
Right. Well, you raise some very interesting points. Maybe I'll pick them up with the different set of vocabulary. Now, in my reading of international law, I always feel that, I mean, we know international law is state-centric, right? It gives states the ultimate power to decide what they want to do or not. The International Human Rights Project is a very new project in the overall timeline of international law. International law has been around for a very long time, but IHRL, as we know it, comes around, you can say in 48, or comes around in the 60s with the ICCPR and the ICSCR. In my reading, states always feel comfortable when they have the power to decide what they want to do with certain aspects or not, be it how they want to treat nationals, be it how they want to treat non-nationals, such as refugees. States always feel very comfortable in their image of sovereignty. They want to keep that control with themselves. This is what one scholar of refugee law in India, Shubhro Prasoon Sarkar, has written in his book. He says that the Indian refugee policy over the decades has been more about political exigencies rather than about having a rights-based regime. As Karthik has also pointed out, it's arbitrary. Another thing that Sarkar points out is that the whole policy is centered on humanitarianism rather than, again, having a certain predictable rights-based mechanism. So that's what the Indian refugee policy has looked like over the last couple of decades, which is, again, as I pointed out earlier, is also visible in how the Ministry of Home Affairs treats certain groups versus how it allows UNHCR India to determine the status of people coming from other countries. So, I mean, one can clearly see why the MHA would be more comfortable in keeping that control over determination of refugee status for Tibetans and people coming from Sri Lanka, and governing their current living conditions as it does. So states always want to keep that control with themselves. Now, I guess with this, I would like to go back to Karthikeyan, and then we can have a dialogue over this. I wonder what he thinks.
So I think if so, my submission would be that national security consideration would be better defended if we have a policy in place, because then there will be demarcated powers assigned to the state, and also we can balance our international obligations towards genuine refugees. And unless we have a draft or a policy, we can't, like, if the state wants to differentiate between Rohingyas and Chakmas, and prefer Chakmas and Sri Lankan Tamilians over Rohingyas, that I think if India has some historical realities to that okay, demographic changes in India have led to geopolitical changes in the past, so these are realistic considerations which the state owes to the people of this country, owes to the national security of this country. And I think if that intelligible differential the state wants to use, we can have a law and we can actually make it into a provision and empower the state to do that. The problem lies where there is absence of this regulation, and the state picks and choose, on the basis of we don't even know what the intelligence report or the intelligence survey is. It's just that there is this intelligence check, and that's how the government decides. But we need a proper system where these things can be judicially revised, and there is a check on of asylum tribunals on these things. So that is what I would like to say at this moment, that national security considerations are better defended when we have a law assigned to this particular issue.
Yeah, thank you, Karthikeya. If I may just add a few things to that. Um, the current legal regime pertaining to the status of refugees in India involves a very interesting piece of legislation which has been at the forefront of a lot of debate recently, the Foreigners Act of 1946. So any person, this is because of the lack of refugee law in the country, any person who is entering into India, who is not a national of India, who is not a citizen of India, is subject to the provisions of the Foreigners Act. Foreigners Act carries it's an old law. It was enacted to regulate the entry and the movement of enemy aliens, as the term was understood then, during the war and post Second World War, and it has remained in its present form. It has in fact been made even more robust with a new set of rules in 2019 to again govern certain affairs in Assam regarding to citizenship. So refugees in India are subject to Foreigners Act, which does not give them any rights. The Foreigners Act is a prime example of an extremely, I would say, inward-looking and extremely narrow understanding of movement, and it keeps the whole control. It keeps the whole control in the hands of the state. It is all about that national security interest, but it does not balance the interest. It's not proportional to the interests of people who might be migrating because of a disaster, because of persecution, or because of certain other reasons on specific grounds that they may face in our neighboring countries. So this is quite contradictory. You may think at this point, right? You think that, okay, India is a generous host country. We let a number of people in, a significant number of people in, but yet it's the system is so hard to predict. It's so arbitrary at that level that the courts do not get to say much about this. The courts are not really involved in this assessment of who is a refugee in India and what shall their rights be. And if we look at what kind of cases the Indian courts have adjudicated over the years, we can count them, and they're a handful. I mean, they're not that much. The Rohingya cases are, in fact, the Rohingya case, Mohammed Salimullah, is being heard at the Supreme Court now. The Supreme Court has taken some positions which contravene, which may in fact violate international law. And there's also been this judgment by, I think, Manipur High Court earlier this year about the status of Rohingya refugees in India. So the point of predictability in the interest of non-arbitrariness, it's absolutely crucial, as Karthik has pointed out, to have a refugee law, to have that sense of a judicial determination of refugee status rather than something based on shifting political realities, because these interests need to be balanced. Also, most importantly, this is one point I would strongly make in favor of ratifying the convention, although we know that's a very I don't know, unreal dream, I would say. That even the Refugee Convention allows the signatories, allows the parties to it, to suspend certain rights in some situations in the interest of national security and public order. So there is that balancing factor present in the Refugee Convention as well, although scholars have pointed out that that may be a very narrow ground to suspend refugee rights. So because of certain other rights that are guaranteed in the convention, where the convention says, for example, that as far as possible, refugees shall at least be treated as how other aliens are treated. Let's say, other aliens being migrants, economic migrants who have a visa, who gain lawful entry into the country and they're living that way. Then the convention says that refugees should at least get that treatment, if not something more. But the Refugee Convention contains that national security way out for certain rights.
I would just like to add on the Foreigners Act bit, because we have some knowledge about the act due to our academic or professional interests, but majority of people of India might not know this. So I think, just as a primer, I would say that Foreigners Act treats a illegal alien and a tourist of this country in the same way. So if a police officer thinks that there's something wrong with you, he can deport you, and there can be no check on this particular power under the Foreigners Act. And that is what makes it so scary, because Foreigners Act was made by a colonial government to suppress, to occupy, to advance its occupation. And it's quite sad that, like many other laws, we are still following it. And we didn't make any proper, like, good revision or amendment to this act. And so that is that. Secondly, I think asylum system involves a lot of things. So if there is a code for asylum or refugee law, it would cover, how, who, first of all, the definitions, then it will cover how the case would go what are the legal aid and the other sorts of aid the government would give, what will be their status within the country, and then what are the deporting powers and how can you like on what basis your case can be rejected. And all these things are missing in this country. It's only the Supreme Court sometimes using Article 21, expanding its definition way beyond, it's that is also arbitrary because Supreme Court decides everything. If you read Article 21, it basically covers every aspect of human life. So it is not a very liable solution to always cite Article 21 in all problems we face. So which is why also an asylum system is very important. And considering, now I think Abhivardhan also pointed about the demographic concerns of the Northeast, and I think I'm no expert of national security, but I don't think it takes a lot of expertise to see that national security consideration in Northeast are very sensitive. Considering if people have studied the political history of that area, they know how insurgencies were quite active there. The longest insurgency in this country is not in Kashmir but in Nagaland. So this is something which we need to consider. And in Northeast India, there were insurgencies, the entire Assam movement against everybody, non-ethnic Assamese. So all these things make that particular area very, very sensitive. And if, because see, if individual refugees are coming, it is not a big problem for this country to cope up with this or manage people. It is only a problem when thousands and thousands of people come en masse. That is where the problem lies. Because in this situation, certain countries, I didn't mean countries, certain states might have a huge problem when mass influx of refugees enter that territory. And considering how foreign powers have been active in provoking and aiding the insurgencies in Northeast, for example, Pakistan and China, that all makes it way sensitive. And considering the Northeast is joined by a Siliguri corridor, considering all these things in the long run and over the period of time makes it very, very sensitive. And that is what made me write this article, that this particular issue is not discussed at all. We talk about illegal migrants coming here, the only solution people say throw them out. I understand that there are problem. Demography is a problem. Demographic alteration, rapid demographic alteration is a problem. I recognize that, and in Indian realities, these changes have changed the geopolitical politics of this country. So I understand that and acknowledge that problem, but I still think that this problem cannot be managed at this level. What we have right now, the current regime, I don't even want to call it a legal regime because it's absent. The absence and arbitrariness which we have right now is not going to satisfy international obligations of India, and not it will not be able to help actually the people who need help, and would also fail in defending India's national security. So that is all my submissions are.
Just to,
Before
yeah,
sure,
sorry.
just 1 minute, and this is a question to all of you, just a slight modified question. A very interesting point raised by both of you. So the reason why I said and it was more of an administrative incompetence issue was only because that administrative incompetency is a long run problem in India. So, for example, Karthikeya mentioned about the very colonial nature of the Foreigners Act. What happens is that whenever you have issues with the constitutive machineries which you have already in a particular subject matter of law, let's say, I can start talking about taxation law or any other field, okay, and we can go on that, but not, of course, for this discussion. What happens is that since this administrative incompetency has first order, second order, and third order policy effects, unless and until the administrative machinery is up for any larger change, it doesn't happen. In India, the thing is, and that is where I think when you mention the point of political exigencies as to what leaders do it and they give statements, why do they do it? And I'm not mentioning about any particular minister, because even when the Mukti Bahini thing happened in Bangladesh, very ironically, even at that time, the ministers in the union government had to be quite hawkish in their rhetoric. And what happens with India is that we have a Westminster form of government wherein the IAS and all of those have a larger scope. Ministers only make the decisions, the implementation happens with them. Ministers definitely can say, okay, fine, we ratify it, or you know what, we are just consultant. Unless you have somebody like these days, Nitin Gadkari, who is very, very interventionist when it comes to the, his own ministry, even in his MSME ministry, when it comes to return of income of many MSMEs, he was very, very hawkish about it. That you know what, the IAS have to make this happen. There has to be an accountable policy for MSMEs for 60 lakh MSMEs. So the reason I pointed out that example was, I think even in this, since Karthike mentioned chicken's neck, which is the Siliguri corridor, and the issue with China, I think the question which I would pose is, maybe point I would pose, not question, is that maybe it is more about a series of incompetencies which have been repeating, and there have been acknowledgement of the incompetency. There have been some political acknowledgement, maybe there have been some legal acknowledgement. Otherwise, why is it that courts go for expansive interpretations of 21 at the first place, Article 21? They go it because of their role in policy. Otherwise, so much jurisdiction can be used for other causes as well, or maybe not. That's a different question altogether. So I think now over to Ashish. I think he wishes to say something. So sorry for that. I just wish to make this discussion enriching for those who being watch it, and that's why I put this point of administrative incompetency in larger scale. Yeah.
Right, that's a good point, Abhivardhan, and I mean, I guess I would agree with your interpretation of the issue that courts have to step in because executive has not fulfilled its role over many years by not even trying to debate over this law. As Karthike pointed out, Shashi Tharoor tried to table this bill. Before him, Varun Gandhi and Rabindra Kumar, I think of BJP, had made attempts to table a bill, which was those bills in my recollection were quite nascent. The Tharoor bill was a bit advanced in comparison, but yet there was no parliamentary debate. Something which I think at least was deserved by that bill. There should have been some discussion which would have given us a hint of what the executive may want. And so the courts have been trying to fulfill that rule. But then again, because the courts are not adjudicating based on a written legislation, the courts are also vulnerable to individual interpretations by judges. And in Indian courts, international law has had a very, I don't know, tumultuous understanding by Indian judges. They're very receptive to it in certain areas and not so much in others. It's very hard to predict again. Something I wanted to point out for your audience, because at this point your audience might think that we've been going on about law and not talking about national security. With that, Karthik raises obviously a good point about the geopolitical issue in relation to China and in relation to Assam. I wanted to raise another important national security issue, not pertaining to geopolitics, which is of a nation which we've been historically friends with, the Maldives. Now, the Maldives will sink. We don't know when. We don't know to what extent. Some estimates say it might, and the island nation might eventually, go under the sea. What will happen to the people of the Maldives? We know Indian history with Maldives. We know what the governments previously have tried to do. Despite everything, there's a very friendly relationship, and it is a national security issue after all to assert dominance in the Indian Ocean, to counter increasing Chinese influence, because the recent happenings in Myanmar and in Sri Lanka with Chinese ports coming up have not been so welcoming towards Indian foreign policy. So India really needs to be receptive to the inevitable disaster that will strike the people of Maldives. Now, in these situations, if we had a law which would, again, very optimistically cater to climate refugees, could help the people of Maldives, help them maybe resettle in India, help them maybe remain in India for some time while they sort of envision other solutions, but we don't have that. Now, there are talks that the Maldives government is in dialogue with India and Australia to relocate its population. And this is again one very rich area, one very rich unexplored area of international law as to how that agreement will go. What will be the form of government of the Maldives? Will it be a government in exile, the sort of government we see of Tibet in Dharamshala? Or will it be some other innovative arrangements? That's another non-geopolitical national security issue that we must take into account while talking about asylum and refugee law vis-a-vis India.
Great. Karthik, you wish to add something?
Yeah, Ashish has pointed out the Maldives, and also it is also a very interesting topic which is beyond this discussion. But I would just like to mention that when the island state submerged under the sea, so there is no land. There's a separate debate about the recognition of state in this because Montevideo doesn't cover all these things. And the solution which people talk about relating to this particular aspect is that the government in exile will go somewhere. So government will of course go somewhere in this area, be it China or be it India or maybe some place in Arabia or somewhere. But there is a significant thing that we'll any day anyway we'll have to host the government, and this will happen. This is going to happen. If people doubt this, just see the map of Maldives on Google Map, and you will see how that country works. It's all bridges. It's a Venice, a country like Venice. So that is how the situation is there. And coming back to this topic, I would say that uh, that it is very important for us that we have discussed this, that we need a law, but also additionally I think regional cooperation or regional treaties specifically targeting all these issues might add to the development of customary international law, which might be used other in other places in the world to such situations. And I think it's very important for Indian government to cooperate with Bangladesh. Now, this is all a very positive and wishful thinking that this would happen, but considering the domestic issues that we are facing in Bangladesh, we are seeing the rise of extremism there, and how Sheikh Hasina, responded to the recent attacks on minorities. I think it's a very positive thinking to that Indian government and Bangladesh government might come to terms regarding this, because there are many other pressing issues. But this is how we can contribute to this thing, that if these things are discussed, it becomes a part of the part of discourse. Maybe it would be considered by the policy making body in this country. And this is something which we need to discuss now, because this is how we can prevent or be ready to manage the problem in the future. And I think one of the major important point outside as a foreign policy level would be to raise awareness regarding this issue and sign multiple regional agreements with Myanmar, Bangladesh, Maldives, Sri Lanka. And this is very important, because this is how we can we can manage this allocation of population and other stuff, and how the resources would be managed. We could also prepare for the funding. All these things are, so this is how the states who want to become something in the future do. You think for the long run, and then you plan, and then when the situation arises, you rise as a hero, because you are ready to face that situation. But we have always been unprepared when we face a problem, which is why I think this is a very good episode which you have hosted, that at least whoever watches this might disagree or agree with it, but it would be a part of this discussion.
I certainly appreciate that. And to conclude, we have a very important final point to discuss, which is the margin of appreciation doctrine from Karthike. So please give your sermons and please explain what you mean by it. And maybe Ashish can put forth his additional comments.
In that article I suggested margin of appreciation, and I would say that because my particular academic areas of interest is basically international law and basically state sovereignty. So I was working in a very different arbitration thing, which I when I came across this particular doctrine, and I used this doctrine to advance my argument there, to because it satisfied the state practice part. And then it gave me an idea, because this particular margin of appreciation deals with human rights obligations particularly. It is a practice which is adopted by the European Court of Human Rights. And through this doctrine, there is a provision for derogation under ECHR, where the state, invoke derogation, and they balance their uh, pressing issues with their human rights obligations. So the court uses this doctrine to assess the proportionality elements, etc., and to also provide a space to maneuver for the state to advance national security concerns, whilst managing or balancing its human rights obligations. So this is how I say this particular doctrine, if adopted in through an act, or the principle is inculcated in the act, or asylum courts, which I really want should happen in India. There are asylum tribunals everywhere and a court of appeal. If this happens, I think this would be a very important lex specialist which we need, because all we talk about are abstract legal obligations, human rights obligations, article 21. All these things are abstract. What we need is a bill to materialize all these provisions and principles together, so that the state has some policy, and we could avoid a policy paralysis which we are very habitual of.
Ashish, would you like to add something? Okay, seems like there's some network issue
Yeah,
from
I think
Ashish's side.
he might join in 2-3 minutes, but yeah. So again, a conclusion point, as you said, that there is a serious problem with the state incapacity, or the state is not very effective in managing. Yeah, this is a very important chart which you have raised, and I think I would like you to explain a bit.
Sorry, I could not hear the last 30 seconds or so
No
because of
problem.
some
No
issue.
problem.
Um,
Yeah.
Yeah, I think Karthik, I mean, the bits that I heard Karthik was very well explaining the marginal appreciation, and that sort of, I mean, I would just reiterate my point about states in those kind of situations can, uh, I don't know, benefit, I guess, from marginal appreciation to reiterate their sovereignty, their sovereign interests, including national security interests, and having a certain understanding of the law and applying it in a certain way. So in that way, India can tailor a refugee legislation, asylum law, uh, keeping in mind India's geopolitical, national security, public order considerations, India's, or as you say, India's desire to become, as you say, a big state or to become a regional power. So that doctrine could in fact come in handy. That sort of helps a state to assert its sovereign interests. So I definitely agree with that analysis.
Great. So, with this optimism and much satisfactory discussion for those who will binge watch this in future, I really wish people binge watch this. It's a very informative discussion we had. I conclude the second dialogue of the Indo-Pacific Mobility Forum. But as I have said, the forum has not ended yet. We are going to have an excellent discussion on Indic languages and artificial intelligence at 7:30 p.m. I have a really interesting set of panelists who will be discussing about, in the case of knowledge economy, how can Indic languages be taken into consideration and how can it shape according to the national education policy of 2020. This is a very interesting point of discussion which we will have at 7:30. So till then, please wait as Industry gets live. And on Internationalism Global Podcast, do not forget to share this video. Do not forget to subscribe. What people say at the end of the day, also I'll say, press the bell icon, as we will have more episodes to come in the weekends. I'm so sorry I had to do it cheaply. I did it because yeah, fine. So keeping the fun point aside, I think we really had an interesting discussion. So meet me at 7:30 for Indus Think episode 15, as things have much escalated. So thank you so much, and really had a great discussion. Namova.
Thank you,
Li-
Vardhan.
li-
Thank you for having me,
Likewise,
and thank you,
Aviradhan.
everyone.
Thank you.